Students, the topic of dissolution of partnership firm is very much important from the examination point of view for the law students. Normally, there will be a question with regard to the asking that what are all the different methods in which a partnership firm can be dissolved. So here we have to write the different methods in which a partnership firm can be dissolved. Here there may be also, that is we can expect there may be also one more question in this way also. Describe the dissolution of a partnership firm and the dissolution of partnership. So here we should not get confused with regard to the question, that is the dissolution of partnership firm and the dissolution of the partnership. I will later explain with regard to this aspect. And one more, the probable question is that what are all the rules to be observed in settling accounts of a firm in dissolution? That means what are all the rules to be followed after the dissolution? So here one more question connected with this question only. Here, what are the rights and obligations of the partners after dissolution? Here these are all the two questions. They are more or less one and the same. That is, what are all the rules to be observed in settling the accounts of a firm in dissolution? That means after the dissolution, what are all the things has to be followed? So thereby we can come across the rights and duties of the partners will come up. Here earlier also the rights and duties will be there. When the partnership firm is in existence also, the partners were having the rights and duties. But after the dissolution also, the partners are having the rights and obligation after the dissolution only. So these are all the probable questions we can expect with regard to the dissolution of the partnership firm. So let us discuss with regard to the dissolution of the partnership. Here the meaning of a dissolution of a firm has been given. Here the dissolution of partnership between all the partners of a firm is called the dissolution of the firm. Here the meaning is that the dissolution of partnership between all the partners of the firm is called the dissolution of the firm. That is a complete entity. That is the complete entity of the partnership firm which will come to an end. That is, in dissolution of firm, the business of the firm is closed and all its affairs come to an end and the assets and liabilities are settled. So here this is the aspect what we can see with regard to the partnership firm. Whereas the firm is dissolved when all the partners stop carrying on the partnership firm. So this is with regard to the partnership firm. If some partners dissociate from the firm and remaining partners continues the business of the firm is not dissolved. So there is also instance that certain partners they will dissociate from the firm and others they will continue the business of the firm. So then firm is not dissolved, but the partnership with regard to those partners, they dissociate with the partnership firm. It will be dissolved. So that is the basic difference between the dissolution of the firm and dissolution of the partnership. The dissolution of a firm is distinct from the retirement of a partner, because in latter situation others are remaining partners continues the business of the firm and firm is not dissolved. So these are all the things we can see. So with regard to the dissolution of the firm, we can say that the dissolution of the firm is the discontinuation of the jural relation existing between all the partners of the firm. So it is somewhat a sophisticated definition. So here this aspect I have gathered from the chartered accountant the student material aspects. So here in total what we can say, the dissolution of the firm is the discontinuation of the jural relations existing between all the partners of the firm. But when only one or more partners retires or become incapacitated from acting as a partner, it may be due to death, insolvency, or incapacity. The partnership, that is the relationship between such a partner and other, is dissolved, but the rest may decide to continue. So this will be called as the dissolution of the partnership, not the dissolution of the partnership firm. So let us see what are the major differences between the dissolution of the firm and the dissolution of the partnership. So it has been divided under the 5 headings so that there will be much clarity will be there with regard to the dissolution of the firm and the dissolution of the partnership. Here, with regard to the dissolution of the firm, we can see the basic differences will be there with regard to the dissolution of the firm vis-a-vis the dissolution of the partnership. First one is continuation of a business. With regard to the dissolution of the firm, it involves discontinuation of all the business in a partnership. There will no business at all. When the dissolution of the firm is there, there is no business will be there. That is the discontinuation of the business in partnership. So that can be seen under the dissolution of the firm. With regard to the dissolution of the partnership, it does not affect the continuation of the business. It involves the reconstitution of the firm. That means if one partner left, it may be due to death, insolvency, or insanity, or it may be because of any reason. So then there is no need of dissolution of the firm. The partnership will be reconstituted and the business will continue, and the firm will continue, but there will be dissolution of the partnership only with regard to the partners left and their constitution. So next one is winding up aspect. With regard to the winding up aspect, we can see it involves the winding up of the firm and requires realization of the assets and settlement of liabilities. So here, with regard to the winding up of the firm and what happens, there will be realization of the assets and settlement of the liabilities. Whereas with regard to the dissolution of the partnership, it involves only reconstitution and requires only revaluation of the assets and liabilities of the firm. That means when there is the reconstitution has been made, so subject to that reconstitution, there will be some formalities will be made with regard to the assets and liabilities of the firm with regard to the partner who has left the firm. So that is the aspect we can see with regard to the dissolution of partnership. With regard to the dissolution of the firm, there will be complete settlement of the accounts, liabilities, etc. Then with regard to the order of the court, with regard to the dissolution of firm, a firm may be dissolved by the order of the court. The court may order the firm, which may be under section 44 for the dissolution of the firm. But with regard to the dissolution of partnership, the court will not order for the closure of the partnership. So dissolution of partnership is not ordered by the court. So the court can order for the dissolution of the firm only. Next aspect, scope. That means what is the scope? What are the scope we can see with regard to scope? What are the differences we can see with regard to the dissolution of firm and the dissolution of the partnership? With regard to the dissolution of the firm, it necessarily involves the dissolution of the partnership. Whereas with regard to dissolution of partnership, it may or may not involve the dissolution of the firm. With regard to the dissolution of the firm, it necessarily involves dissolution of the partnership. That is, certain times here what happens, there will be dissolution of the firm and dissolution of the partnership at a time. That means the partners, they may decide to end the partnership and they want to dissolve the firm also. So this is what we can see with regard to scope. Here, dissolution of the firm is, it necessarily involves the dissolution of the partnership. So there should be all the partners, they should be dissolved, and after dissolution of the firm itself, we cannot think of existence of any partnership. So with regard to dissolution of the partnership, it may or may not involve the dissolution of the firm. That means they may decide what you call the to complete one juncture, they can close their business with regard to the dissolution of the partnership as well as the dissolution of the firm. Last one is final closure of books. With regard to dissolution of firm, it involves final closure of the books of the firm. There will be final closure with regard to the firm books. There is no further transactions with regard to the any business of the firm. But the settlement of the accounts, it will take place. But with regard to the business of the firm, there will be final closure of the books of the firm. Here, with regard to dissolution of the partnership, it does not involve the final closure of the books. As you know, if one partner he left the business, other partners they will reconstitute and they will continue the business with regard to the even after the dissolution of the partnership. Let us go to the aspect of different modes of the dissolution of the firm. Here under this table you can see very much easily. That means the dissolution of the firm can be broadly divided into two categories. That is by the order of the court and without the order of the court. Under the without the order of the court, we can see from section 40 to 43. With regard to the by order of the court, we can see only section 44. Under section 44, we can see there are 7 grounds are there. One is insanity, misconduct, permanent incapacity, persistent breach of agreement, transfer of interest, continuous loss, and just and equitable ground. Here, with regard to the just and equitable ground, we can that is left to the discretion of the court. Whatever the court which can decide what is just, what is equitable, depending upon the cases, the court may say it may say this is just, this is equitable. So the court may say with regard to the what is just, what is equitable. So that aspect we can see with regard to the court aspect. Here, let us see with regard to the without the order of the court. So here with regard to the without the order of the court, we can see there are 4 aspects is there: by mutual agreement, compulsory dissolution, and happening of the certain event, that is contingency event. So depending upon the contingency of the event, the dissolution will be there. So that purely depends upon the contingency of the event, on happening of certain event. Last one is by notice. So by notice also there will be dissolution of the firm can be done. So let us see the first aspect, that is without the order of the court, from section 40 to 43. So here a mode of dissolution. Indian Partnership Act provides for the following modes of dissolution, that is the dissolution by agreement, compulsory dissolution, dissolution on the happening of certain contingencies, dissolution by notice of partnership at will, and that is dissolution by court. So here what is dissolution we know. Under section 39, with regard to the dissolution, the definition has been given. That is a dissolution of partnership only involves a change in the relationship of the partners, whereas dissolution of the firm is complete breakdown of the relation of partners among all the partners. So here we can see the definition under the section 39, that is the dissolution of partnership between all the partners of the firm is called the dissolution of the firm. So here with regard to the modes of dissolution, here we have to see the section 40, 41, 42, 43 with regard to the dissolution without the order of the court. The first one is dissolution by agreement. As you know that the partners they will come together on the basis of the agreement only. So the main aspect between the partners is that there should be an agreement. It may be through making the agreement in the form of partnership deed also. So there may the agreement the partners they will come together on the basis of the agreement. So in agreement only they can decide. They can decide the future the course of their business and other aspect. Here, according to section 40, a firm may be dissolved with the consent of all the partners or in accordance with the contract between the partners. That means by the contract and agreement, they can decide to dissolve the partnership. So section 40 includes two modes of dissolution. First, a firm may be dissolved with the consent of all the partners. That means a firm, if all the partners they decided to end their business, they don't want to continue the business, so then there is no question of running the partnership firm. So that is the one instance. Another instance is secondly, a firm may be dissolved in accordance with a contract between the partners. That means here the other aspect is that a firm may be dissolved in accordance with the contract between the partners. That means here already there is a contract is there with regard to the dissolving the partnership. So on the basis of the contract also they can dissolve the partnership. That is with regard to the dissolution by agreement. So agreement plays a catalyst role here with regard to the continuing the business or closing the business or winding up of the partnership firm. Next aspect is under section 41, that is compulsory dissolution under section 41. That is under section 41 there is a compulsory dissolution is there. Here there is a compulsion is there. Here there will be compulsion will be there with regard to the winding up of the firm or dissolving the firm. There are so here we can see the compulsory dissolution which will undertake under two instances. So here under section 41 we can see on two grounds the dissolution of the firm may take place. One is all the partners or all the but one becoming the insolvent. So here insolvency of a partner or all the partners insolvency, which will play the important role. So which makes the partnership to end their the business, to end their partnership firm. So that is the first instance. Here what we can see here, a firm is dissolved by the adjudication of all the partners or all the partners, but one is insolvent. Thus a partner is adjudicated as insolvent, he ceased to be a partner. As you know that what is the legal effect? What is the effect when any partner he has been adjudged or adjudicated as insolvent, or when a person has been adjudicated as insolvent, he ceased to be a partner. He doesn't have any more what you call the credentials. He cannot enter into contract, and no action can be taken against him. Here one of the main reasons for this is that when he is adjudicated as insolvent, he becomes incompetent to contract. So this aspect we can see. So here with regard to this aspect of insolvency of a partner, we can find the provisions in both the sections, that is section 41 and section 42 clause D. That is here under 42 clause D also this insolvency plays the important role, that is a dissolution on the happening of the certain contingencies. So here also the concept of insolvency will be discussed. Here there is a compulsory dissolution is there. When any partner he has been dissolved, there is a compulsory dissolution is there. So that is the one of the aspect. Here with regard to the insolvency aspect, there are certain laws are there. That is with regard to the section 41, that is what we can see. One is compulsory adjudication and other is what the procedure to be followed when a firm is to be dissolved by the insolvency of the partner. The deficiency of the insolvent partner is to be borne by the solvent partner. That is normal practice. What should be done when any one of the partner become insolvent? Then for one thing is compulsory what you call winding up of the partnership firm. Then after the compulsory winding up the firm, what procedure has to be followed? So what procedure to be followed with regard to the paying of the debts and paying of the what are all the the aspects has to be compulsorily has to be done after the winding up. That is the main aspect we have to see. So with regard to that one, we can see the answer under the case law of Garner versus Murray. So this is the important case law with regard to the partnership firm. If you don't discuss this case law, then your answer will become incomplete. So here Garner versus Murray, I can make a separate video with regard to the facts of this case. Here today we will take up only the what is the principle has been adopted with regard to this Garner versus Murray is that when a firm is to be dissolved by the insolvency of the partner, the deficiency of the insolvent partner is to be borne by the solvent partner. So that is the principle has been adopted under the Garner versus Murray. Here in India also, this aspect has been followed. That is, the deficiency of the insolvent partner's capital account must be borne by solvent partner in proportion to their last agreed capitals. So this aspect we have to keep in our mind. So here with regard to the compulsory dissolution, this is the one of the aspect, that is insolvency. On the basis of the insolvency, the partnership firm can be closed. So the partnership firm can be closed or that it can be dissolved. The second instance is that happening of any event making the business of the firm unlawful. So when the partnership firm has been running, it may be lawful. So subsequently it may become unlawful by the statutory recommendation, by the any statutory act or act of the state. So likewise, for example, suppose some company is producing the what you call scent, or it is producing some chemicals. So it may be borrowing certain chemicals and mixing certain chemicals, or it may be producing some tablets, and so it may be taking some chemical compounds from other the pharmaceuticals, or it may be using some chemical compounds for the production of the some given tablet. But later the state or the state government or central government or in statutory authority which bans the use of a particular chemical compound, then the partnership firm or any firm which is producing the some what you call tablet that is made to be used by patient, so which no longer get produced. So that becomes if they continuously use that contraband or prohibited chemical compound in the tablet, then it will become the unlawful. So at that time it is as good as closing the partnership firm is better. But if any partnership firm is doing one or more businesses, so at that time one or more nature of the business, suppose one might become unlawful and rest of the other businesses may be lawful. So at that event, whichever is unlawful, that aspect can be closed down, and whichever is lawful, which can be continued. So that we can see with regard to the happening of any event making the business of the firm unlawful. A firm is dissolved by the happening of any event which makes it unlawful for the business of the firm to be carried on, or for the partners to carry on the partnership. So this is the aspect we can see with regard to the second aspect where we can recommend for the compulsory dissolution of the partnership firm. According to this principle, where there are several parts of the contract and one of the parts become illegal, then if the illegal part can be separated from legal part, only the part which has become illegal shall be void and the legal part shall remain valid. So that's what I have said in the other forum with regard to the business nature of the business. Let us go for the next section, that is the dissolution of the firm without the order of the court. Here what we have seen now, so far we have seen with regard to the one is dissolution by agreement and the compulsory dissolution we have seen. Let us discuss with regard to the dissolution on the happening of the certain contingencies. Here, which are all those contingencies under which the winding up of the partnership firm can be done, or dissolution of the partnership can be done. So that is under section 42. We can see there are 4 instances will be there. That is where the firm is constituted for a fixed term. On the expiry of that term, the partnership firm can be dissolved. A second instance is that where the firm is constituted to carry out one or more adventures, that is business or undertaking, then by the completion thereof, the partnership firm can be dissolved. Then is other aspect, that is by the death of the partner, by the adjudication of the partner as an insolvent. What I have already said with regard to the insolvency in length. So here first aspect is that by the expiry of the fixed term, that means a firm is dissolved if constituted for a fixed term. By the expiry of the term, that means a partnership firm will come into existence with regard to this certain term, certain tenure, certain time. So after the completion of the term of the partnership, partnership is completed or exhausted. So then the automatically on the contingency of that event, the partnership firm will become the dissolved. So the term of the partnership being fixed is clearly not a contrary provision under section 42. It may also be noted that here that even after the expiry of the fixed term, by mutual consent, partners may continue the partnership. That depends upon their future agreement between the partners. But when once they decide that the partnership will continue for a fixed term, then thereby the partnership firm will be dissolved. Next one is on completion of the adventures or undertaking. What is the meaning of adventure? Means certain business. So here what happens with regard to the any business? That means they may say we have to cover this area. When we complete this project, when we complete this business in this area, so there is no more interest in continuing the business. So on completion of that adventure undertaking, the partnership firm can be dissolved, subject to contract. That means whatever it may be there we can see with regard to agreement, subject to contract between the partners in a firm, is dissolved if constituted to carry out one or more adventures or undertakings by the completion thereof. So that what we can see with regard to this aspect. Next one is by the death of the partner. That means nobody can know when the death will be catastrophe on any human being. That means that is the act of the God. So that means nobody can expect or anticipate with regard to the death of any person. So by the death of the partner, so it becomes a contingency. So subject to contract between the partner, say firm, is dissolved with the death of a partner. The main reason for this rule is that in law, firm is not a person. It's only a group of person, and the name of the firm is only the collective name of the person who constituted the firm. So this is the reason why in the event of death of a partner, the partnership firm will be dissolved. And next one is, as we have discussed in length with regard to by the adjudication of a partner as an insolvent, subject to contract between the partners, a firm is dissolved by the adjudication of the partner as an insolvent. So this is the aspect we can see. And next one is dissolution of by the notice of partnership at will. So here what we can see, so by the dissolution by notice of the partnership at will, it can also be it is the next aspect. So we have discussed so far dissolution by agreement under section 40, compulsory dissolution section 41. Two aspects we have seen, that is 2 instances we have seen, and dissolution on the happening of the certain contingencies, that is 4 aspects we have seen under 4 instances. The partnership firm, it will be dissolved. Last one is dissolution by notice of partnership at will, that is under section 43. So let us discuss that aspect now. So dissolution of partnership at will. So that is the will of the person plays the very important role. That is, according to section 43 of the Indian Partnership Act of 1932, it has been defined that where the partnership is at will, the firm may be dissolved by any partner giving notice in writing to all the partners of his intention to dissolve the firm. That means any one partner, he may give the notice, and other partners also accept their the person's his intention to dissolve the firm, and they can wind up the partnership firm. So the firm is dissolved as from the date of mentioned in the notice as the date of dissolution. So when here the date will be taken into account. If the date has been mentioned in the notice, from the notice date itself, the partnership firm will be dissolved. It will be called as partnership at will. That is the will of the partners which plays the important role. If no date is mentioned, as from the date of communication of the notice, the partnership at will, it will continue. When the other partners, they receive the communication of the notice, so from that date, the partnership at will, the partnership of the firm will be dissolved. So this is the thing we have seen. That means here under the dissolution of the firm, we are looking into the without the order of the court from section 40 to 43. We have seen by mutual agreement, we have seen, and the compulsory dissolution we have seen. There are two events on happening of the certain events. There are four the events are there under section 42 we have seen, and last one we have seen the by notice, that is section 43. So these are all the aspects by mutual agreement, that is section 40, and compulsory dissolution section 41 on happening of the certain event, that is 42, that is contingencies of event, and by notice, that is partnership at will. So that is under section 43. So these are all the without the order of the court. Let us go for the by order of the court. Here under the by order of the court, we can see there are 7 instances are there. That is insanity, misconduct, permanent incapacity, persistent breach of agreement, transfer of interest, continuous loss, just and equitable ground. So by order of the court, we can discuss under which are all the circumstances the court may ask for the dissolution of the partnership firm. So one is a partner becoming unsoundness of mind. At the suit of a partner, the court may dissolve a firm on the ground that a partner has become unsound mind, in which case the suit will be permanently at the suit of the partner, the court may dissolve a firm on the ground that a partner may become. That is here we are looking into the dissolution by court. So here we are looking at the concept of dissolution by court. So here under dissolution by court, we can see there we can refer the section 44. The court may dissolve a firm on any of the following grounds. Here a partner becoming a unsoundness of mind. That is, if a partner becomes he suffers from any short duration of the unsoundness of mind, the court cannot order for the partnership firm dissolution. So, but if the insanity of any partner it continues, if the insanity of any partner continues, then what happens? So when one of the partners become insane, then any partner may apply to the court for dissolution. There must be adequate proof to show that the partner has been really suffering from unsoundness of mind. If a sleeping partner becomes insane, the court may not order for the dissolution. Here the case law of Kirby versus Kerr is very much important with regard to this aspect. Then we can see with regard to a partner becoming permanently incapable. That means a permanent incapacity will be there with regard to the second instance where the court may order for the dissolution of the partnership firm. That means when any partner has become permanently incapable of performing his duties as a partner. That means Normally, as you know that partners, they will come to together, they will distribute the division of work, and they will perform their duties according to their distribution of work. Then there is no problem. If any partner is incapable of performing his duties, then the court may order for the dissolving the firm. The incapacity may be due to physical ailment, or it may be due to mental illness. So this is the second instance. The partnership firm may be dissolved by the order of the court. The third aspect is a partner guilty of conduct likely to affect prejudicially the carrying on the business. It is normally it is with regard to the misconduct of the partner. Here, what is misconduct? What is not misconduct? Whether it has got any influence on the business, and whether the court can order for the winding up the partnership firm, even though it does not have the effect on the partnership firm. It depends upon the case to case. So here, with regard to this one, I have made a separate video with regard to the misconduct of the misconduct being the reason to ask for the dissolving the partnership firm. But here, whether a guilty person, a guilty partner, whether he can ask for the dissolving the partnership firm for his own misconduct, means here he cannot ask for his misconduct. So with regard to this one, I have done a problem solving question also. Here in exams, what happens? Here, with regard to these grounds, with regard to any aspect, the problems may be given in the law exams. So you should know the concept, whether a guilty person, a guilty partner can become out of his own misconduct, he can ask for the dissolving the partnership firm. He cannot ask. But other partners, they have to prove how far it has got the effect on their business, nature of business with regard to the misconduct. That is, misconduct may be anything. It may be adultery. It may be any aspect. So that is the aspect concerning to the question of fact. So let us go with regard to the next aspect, that is continuous breach of trust, that is willful or persistent breach of agreement relating to the business or management of the affairs of the firm. So this is also very much important. So if any partner willfully and continuously commits any breach of partnership agreement or conducts himself in such a manner so that it becomes impossible for the other partners to carry on the business, that is here a willful neglect by a partner to attend the business of the firm, or continuous quarreling with the any of the aspect, continuous quarreling with regard to the partners, or here these aspects are also very much important from the. So the instances with regard to the persistent breach of agreements are that embezzlement, keeping erroneous accounts, holding more cash than allowed, refusal to show accounts despite repeated requests. So here these are all the instances where we can see persistent breach of agreement. So other than this one, here there are other reasons also there with regard to the persistence of breach of agreement. That means it is no more possible to continue the business. For example, if one of the partners keeps erroneous accounts and omits to enter receipts for the same, so this is against to the holy conduct of the partnership business. So on this ground also the partnership firm can be dissolved. The other things are that transfer of the own interest in the firm by a partner to a third party. That means, at the suit of a partner, the court may dissolve a firm on the ground that a partner other than the partner suing has in any way transferred the whole of the interest in the firm to a third party. So this is also important. Here, a partner other than the partner suing has transferred whole or whole interest in the firm to a third party. So it is against to the principles of the partnership firm. So here, with regard to this one, the court may dissolve the firm at the instance of the any partner. So that is this is also on this ground also the court may dissolve the firm. The next one is perpetual loss. That means if as you know that the partnership firm has come into being under some agreement as we have seen under section 4. So in order to make the a profit, the partners they will come together, they will make agreement. So all those things are there. So here if there is any continuous loss is there. So at that event some partner they are ready to continue with the business, but there is no question of running the business. Then any partner, one of the partner, anybody, they may file a suit. So the court may dissolve a firm on the ground that the business of the firm cannot be carried on. So to save from the loss, the court may order for the dissolving the partnership firm. So this is also one of the ground we can see with regard to the dissolving the firm, that is continuous losses. So the court may grant the order to dissolve the partnership firm. And last ground is just and equitable. So here, what is just and equitable? It is totally discretionary of the court. So it is totally discretionary of the court. Then the court may take any of the ground. Here it depends upon the discretionary of the court. Here normally what are all the grounds the court may ask for dissolving the partnership firm. Under this heading is that deadlock in the management, loss of substratum, gambling by any partner in a stock exchange where the partners are not talking terms between them. That means when the partners themselves they have got they don't have the what you call the friendly feeling towards each of them. They have got some sort of the enemy sort of the characters, and they develop some sort of the unruly behavior. So at that time it is as good as they should get rid of that partnership firm. So under these headings the court may grant the for the dissolving the partnership firm. So at the suit of a partner, the court may dissolve a firm on the ground that it is just and equitable that the firm should be dissolved. So on the ground of just and equitable way, the court may order for the dissolving the partnership firm. So we have seen all these aspects, that is the modes of dissolution of the partnership firm we have seen. So here we have seen we have discussed all the aspects concerning to the mode of dissolving the partnership firm. So first we have seen with regard to without the order of the court under section 40 to 43. So under section 40 we can see by mutual agreement. Under section 41, that is compulsory dissolution, we have seen there are 2 instances will be there on happening of the certain events. 4 instances we have seen, and by notice also there will be the dissolution of the firm will be done. So this is the one aspect, that is without the order of the court. And with regard to the with the order of the court, we can see there are 7 grounds are available. That is insanity, misconduct of the partner, permanent incapacity of the partners, persistent breach of agreements, and we have seen which are the examples for the persistent breach of agreements, and transfer of interest to third parties, and continuous loss of the partnership firm, and the last one is just and equitable ground that is left to the discretion of the court. And we have discussed which are the normal grounds on which the court may ask for the dissolution of the partnership firm under the just and equitable ground. In the next video, we can discuss the other aspect, that is with regard to the what are all the rights and obligations of the partners after the dissolution, or it may be asked with regard to the what is the procedure to be followed with regard to after the dissolution of the firm. That is how the settlement of the accounts can be done. That is the rules to be observed in settling the accounts of the firm after the dissolving the partnership firm. So this is with regard to dissolution of partnership firm. Here in the exams, there will be straightforward question will be there with regard to the methods of dissolving firm. So here you can write something with regard to the some aspects with regard to the what is meant by dissolution under section 39, and you can if you like to explain what is the difference between dissolution of firm and dissolution of partnership, it is well and good. And otherwise you can write the you can explain all this what you call the methods of dissolving the partnership firm. So this is with regard to the aspect of dissolution of the partnership firm. In the next class we can see with regard to the method of settlement of accounts or rights and obligation of the partners after dissolving the partnership firm.